Good morning, everybody, and welcome to our local government training partnership session. This morning we are going to be looking at pre-election notice periods. This isn't my area of expertise, so I won't be speaking on this today, but I will be joined by Mark Heath, who I'm just looking at who we've got attending. Some of you will know. I also would like to introduce you to the latest member of our team, Lisa Kirkman. Lisa's just joined us from Winchester City Council, and Lisa will be doing similar sort of work to Mark, myself and Charlotte in relation to sort of local government, public law governance, all of those very interesting and important areas. So good morning, everybody. I think we're going to take questions at the end of Mark's presentation. If you want to put things in the chat box, I think you can do that, and we'll scoop them up at the end. Mark, are you comfortable with dealing with it like that?
Fine with me.
Lovely. Okay, well, without further ado, I will hand you over to Mark. Thank you.
Brilliant. Thanks, Al. And can I have the next slide, please, Remini? Fantastic. So good morning, everybody. As Al said, I'm Mark Heath, and I'm going to be talking for about 45 minutes or so, and then I'll take some questions. So what I'm going to cover is what the responsibilities are arising from the pre-election notice period restrictions. I have to say some words around what PERDA is and is not, and why it's not applicable to local government. And then I want to go through the restrictions themselves, and in particular, practical and operational issues, as many of the queries that arise in relation to the pre-election notice period actually fall into practical or operational issues box. We did a little straw poll recently at a conference I was doing, and it's about the 4th or 5th year that I've been talking, I think either before or after Tim Straker Casey. Both of us are still getting election queries, probably 25 to 33% as a very, sticking a thumb in the air level, where they're not in fact election queries, they're in fact pre-election notice period queries. So there's still a lot of issues kicking around over this. So I hope this is timely and helpful. But as Alice said, questions at the end. And you've got my email address. Next slide, please. I think one of the most important things to sort of get this get square in everyone's minds before we go too far down the track with the pre-election notice issues is that it's not a matter for the returning officer or elections team. It is a matter for the council, and often the lead officer dealing with it is the MO, sometimes in conjunction with or the CEO. But it will be regarded by some as an election issue because, after all, the additional requirements, and usually, dare I say it, the issue arises in the context of an electoral contest of some sort, with party A either wanting party B to disclose something, to continue with something, or officers feeling it should be stopped because of a forthcoming election. So it's tied into the election, but it is a matter for the council. So it might be raised with the returning officer and conflated and linked into the running of the poll, but even returning officers and their elections team need to know enough about this to be able to understand what the answer might be or what the issues are, but it ultimately is for the council to deal with, and quite possibly the monitoring officer. And it's important that it's dealt with in that context, and that it's not dealt with by the returning officer. Now, when I was at Southampton in a substantive role, I spent a lot of time as both monitoring officer and returning officer, and I used to have two emails, and I used to separate the two issues so that I could be seen to separate them. And I had my deputy deal with quite a lot of the issues associated with the pre-election notice period because I was the returning officer. And despite the fact I tried to split it, people still tried to conflate the two. The other part of responsibility is, once one's established that this is for the council to deal with, not the returning officer, although they need to be aware of it, alive to it, etc. How is it dealt with within the council, and who makes the decision? I used to describe this as something resembling a bit of a hospital pass game. Often it's left to the monitoring officer to deal with. Sometimes there are better ways of dealing with it. And certainly one of the things that I advocate is the drafting of, or having some guidelines that are circulated well in advance of the notice of election going up, and doing that can enable whoever's drafted them, and I suggest it's the monitoring officer who should draft them, but if they draft it in partnership with the chief executive, delineating who is responsible for determining practical and operational issues. That need not, and perhaps dare I say it, ought not to be the monitoring officer, but often they can be the person who is tasked with finding a route to stop or start something where perhaps there isn't a legal issue, where, dare I say it, senior management perhaps might be better placed to make that decision in respect of the areas for which they are responsible. I will come back to that. It is a very live topic under this heading. So if I could have the next slide, please. Now, this area is often mistakenly referred to as PERDA. PERDA is a convention which applies to central government, civil servants and linked bodies. It's a term that used to describe the convention which originated in Whitehall, but it's never been codified in law. And in fact, there was a case, I think it was 2017, where the government was challenged about the release of a clean air strategy, where the courts took great pains to say that whilst it was a convention, it was not a rule of law and therefore was not in the sense of a piece of legislation like a statute or regulations binding legally. It found its origins with the Treasury when it was long established that the Chancellor of the Exchequer should avoid discussing a budget before its official announcement to prevent repercussions in financial markets. And now, by extension, within central government, it's the principle of avoiding active engagement on politically sensitive matters and facilitates due process, since the governing party doesn't use its power for potentially unfair electoral advantage or commit its successor to significant decisions that it wouldn't wish to have made. And it also assists, and this all applies to central government, in maintaining the impartiality of civil servants, because, of course, unlike council officers who work for the council, civil servants implement government policy, give advice and then implement it. But where the policy may change, as what happens when you get to a UK parliamentary general election and change of parliamentary control, the civil services are relieved of this duty in relation to non-essential policy which might bind a future government that is in political disagreement. So PERDA has a very specific meaning relating to a convention in place in central government and very specific application, but it is different for local government. So although it has been used as shorthand for the rules applicable to local government, we've moved away from that. And even the Local Government Association's guidance is no longer called PERDA. It's now called the Pre-Election Notice Period. 3 cheers. But you will find people still endeavour to try to conflate central government PERDA restrictions into local government. Local government has a statutory basis. It's been codified in primary legislation, secondary legislation, and then some guidance, and guidance to which councils have to have regard to, as I will explain shortly. And because of that, it's in a different place and a very different status. But PERDA, excuse me, as a concept does not apply to local government unless a council chooses to adopt it and apply it in a particular way. Again, I shall come to that when I talk about the guidance and why there are certain aspects, not PERDA, but there are certain aspects that sit outside the legislation where it is wise for councils to identify in guidance that may be reasons why matters need to be deferred. Next slide, please. So broadly, even more broadly than is on the slide, the sort of restrictions that can apply are, first of all, those that arise under the legislation, under the 1986 Act or the Code, or those that arise because of practical or operational issues, for example, a proposed decision or consultation, and doing it during the pre-election notice period is for very good reasons unwise, but isn't in breach of any law or doesn't seem to fall foul of the code, etc., etc. So you've got those two headings that you need to bear in mind, whatever you're doing falls under, and also how you then and who then makes the decision about what does and does not go ahead. Next slide, please. Now, a starting point is Section 2 of the 86 Act, which I will go through because although it hardly ever arises, the starting point is always to consider Section 2 because this is the absolute prohibition on local authorities publishing material of a party political nature. It's very clear. It's an absolute no-no. It's a breach of the law if it's done. Next slide, please. In determining whether material under Section 2.1 falls within the prohibition, regard has to be taken of a number of factors. First of all, the content and style of the material. What does it look like? What does it say? The time and circumstances of publication and the effect on those to whom it's directed. So, for example, and I've never heard of this, but a council choosing to publish material during the pre-election notice period saying Councillor X, the leader of the council, is a fine fellow and a great member of the XYZ party, and this council believes you should vote for the XYZ party, clearly covers all those bases and would be as illegal as you could possibly get to. But as I say, I've never heard of a council actually doing that, but you should be aware that it's there. Next slide, please. The other factors that need to be taken into account is whether the material promotes or opposes a point of view on a question of controversy, identifiable as the view of a political party but not another, references to political parties or persons identified with them, and next slide, please. Where the material is part of a campaign, the effect which the campaign is designed to achieve. So that's the prohibition under Section 2. So just bear in mind that there is a statutory absolute prohibition. Things are rarely that bad. I've had people attempt to suggest that Section 2 applies, but no one's ever made it. Next slide, please. Be aware that a local authority can't go around giving financial assistance or assistance to others to then do that which is prohibited under Section 2(1). That's what this section says. So you can't give, council can't fund a voluntary organisation or another organisation using public funds to then go and spend those public funds indirectly, but on things that the council's prohibited from doing. That's equally unlawful. Fairly obvious stuff, but keep an eye on that. And bear in mind that under Section 5 of the 86 Act, as amended by the Audit Commission Act 98, the council must keep a separate account of expenditure on publicity. And one of the reasons for doing that is so that if people wish to go back and challenge what has been spent on publicity and whom by, so for example, has the council passed money to third parties to spend on publicity, who, what, when, where and why can be ascertained. Next slide, please. Now, when one looks at, in relation to the pre-election notice period, those things that might fall onto what I would describe as the more legal side, it's more likely that far more likely they're going to arise in relation to the Code of Recommended Practice on Local Authority Publicity, or the Code as I'll call it for short, than Section 2. So I will spend a bit more time focusing on this, and specifically the provisions that apply during the period of sensitivity, or post-notice of election up to polling day. It is in essence a series of obligations. There's the statutory prohibition, and then local authorities are required to have regard to the Code of Recommended Practice on Local Authority Publicity is the second part of the limb. The Secretary of State has the power to issue one or more codes, and these cover content, style, distribution and cost of local authority publicity and anything else they think fit. And local authorities have to have regard to the provisions of a code in coming to any decision. One of the issues that frequently arises is what does have regard to? Well, it's not having to follow it slavishly, but I think I would say that you should follow it unless you've got good reason, good lawful reason not to follow it. Publicity is defined very widely in Section 6 of the 86 Act, and so that's the same definition that therefore applies to publicity in the Code, which is issued under Section 4(1). It's any communication in whatever form addressed to the public at large or a section of the public. So it covers obvious publicity like speeches, leaflets, newspapers issued by or on behalf of the council, but also posters of sponsorship events, the colour of floral displays. I would suggest lights in a clock tower. Yes, we had that in Southampton. The lights, which used to be multicoloured and then were blue, were changed to red. And you can feel the politics coming out of it. And it also covers photos. So it's very broadly construed. Be aware that sections 4A and B, which were inserted by the Audit and Accountability Act 2014, gives the Secretary of State the power to give directions and make orders requiring authorities to comply with one or more of the recommendations in the Code. They may give a direction to a single named authority, that's the Secretary of State can give a direction to a single named authority or a group of them, or indeed all of local government, requiring compliance with some aspect. Now, the Secretary of State has only so far issued directions restricting the frequency of the issue of local authority council newspapers to no more than quarterly, except for parish councils, who should not issue it more often than monthly. That was challenged in the High Court, the citations on the slide, and it's just worth noting that the High Court held in a series of joined up cases that the Secretary of State had acted lawfully. There aren't that many cases around the Code and the 86 Act. That's one of the few. But the Secretary of State has done no more in terms of power of compulsion than that. Next slide, please. Now, the current Code of Recommended Practice was issued under Section 4 on the 31st of March 2011 and has not been revised. And as I've mentioned, Council should have regard to the provisions of the Code, which I say should be follow it unless you've got really good lawful reason not to do so. I've mentioned the two limbs, the statutory prohibition in Section 2 and the Code, and paragraph 3 of the Code itself makes it clear that the two limbs are completely distinct, in that it says nothing in this Code overrides the prohibition in Section 2 of the Act. So just be clear that the Code doesn't override the prohibition doesn't override the Code. They're completely separate but live in their own world. I've mentioned the breadth of its scope in terms of the broadness of the definition of publicity. And having set that context, the Code then goes on to set out 7 principles which local authority publicity should comply with. And that is at all times, including during the period of heightened sensitivity, the pre-election notice period. So the 7 principles are important to bear in mind because they apply as well as the additional obligations set out under the Code during this pre-election notice time. And those 7 principles are: the publicity should be lawful, cost-effective, objective, even-handed, appropriate, have regard to equality and diversity, and be issued with care during periods of heightened sensitivity. So it's one of the 7 principles, but the Code then goes on to expressly state what it means by that. Next slide, please. So I'm going to run through the paragraphs that apply in the Code to the election specific timeframe, pre-election specific timeframe. But as I say, don't forget the 7 principles because they still are there. You're still obliged to comply with them, and you're obliged to comply with the prohibition. These are just things on top of all of that, from the point when the notice of election is put up to the close of poll on polling day. Now, a very granular point is the notice of election must be issued no later than 25 working days prior to polling day, which, if I remember rightly, is the 27th of March for the May 2023 elections. Many returning officers, and I am the same, put it up a day or too early. I put mine up on the 25th, I think it is. 24th, Friday, 24th of March. So that means the pre-election notice period in Southampton starts on the 24th of March. It doesn't start on the last day that the notice has to go up on. It starts on the day the notice goes up on. 2 or 3 days may not make a big difference, but it's worthwhile knowing. And certainly if you're going to issue guidance, you want the guidance to have gone out before the notice of election goes up so that you've drawn your line in the sand. But we'll come back to that. Going back, however, to the specific provisions that are in the Code that need to be had regard to, followed unless you've got good lawful reason not to. 33 says the local authority should pay particular regard to the legislation governing publicity during a period of heightened sensitivity before elections and referendums. It may be necessary to suspend the hosting material produced by third parties or to close public forums to breach restrictions. So if the council is hosting material from third parties over which it doesn't have control, important point, or public forums, again, over which it doesn't have control, the authority may well have to shut them down or take greater control before things are published in order to make sure there's nothing in there that breaches any of the rules under the Code. Next slide, please. 34. During the period between the notice of election and the election itself, and that's once polling day has been and closed down, the count may still be coming, but it can't have any influence because the votes that are going to be counted have been cast. Local authority shouldn't publish publicity on controversial issues, report views or proposals in such a way that identifies them with members or groups of members. Stop. Please note, members or groups of members. Please also note it talks about local authorities where there is a notice of election going on. It doesn't say the local authority who is conducting the election or the local authority where the returning officer for that authority is conducting the election. So where you've got a dual-hatted situation, districts, counties, for example, and one of those tiers has an election, there will be an impact on the other. And it's important to understand that because the mischief that the legislation that the Code is attempting to address is to restrict the expenditure of public money by public authorities during the pre-election notice period that might be regarded as adversely or incorrectly affecting the voter. So clearly, it's got to be applicable across the whole of the public sector, across all local authorities, whether they've got the election or one of the other tiers has the election. So be conscious of that at all times, so that when there are, for example, county elections, it may well be that if you're in a district council, you have to issue some sort of guidance so that people are aware that this is going on in their patch and that the restrictions do apply. Publicity relating to individuals, it goes on to say, involved directly in the election shouldn't be published by authorities during the period unless authorised or under statute, but it is permissible to give factual information identifying the wards, parties, the candidates' elections. Of course, it's necessary to do that. And as a returning officer, I have statutory notices that I have published on my behalf through the council's website. There's absolutely no issue with that. But your comms folk will need to take a very strong line and with support in terms of expenditure of council money on comms that contains, for example, lots of photographs or quotes from those contesting the poll. Next slide, 35, please. Thank you. In general, local authorities do not issue any publicity which seeks to influence voters. That, in one sense, is a crystallisation of the policy. During this time, from the notice of election up until the close of poll, local authorities cannot issue any publicity, thereby publicity issued at the public expense, which seeks to influence voters. That's the target, and that's probably a sentence that's worth keeping in mind. When you get questions that say, but the current leader, who is a candidate as well in the forthcoming poll, has gone off and talked to the local paper editor. Has there been any local authority activity, expenditure? Has the local authority issued any publicity, or has the leader just gone off and had a chat with the editor of the local paper? Is it a matter for the council? Probably not. In fact, it's always fact specific. The details matter. But there are issues to unravel in relation to that, and it is, as I say, a focus on what the local authority spends its money on and what the local authority does during this time, rather than what other people necessarily do off their own bat. As it goes on to say, the general principle is subject to a statutory provision which authorises expenditure. So there is, for example, and it goes on to say this, which I won't go into detail, but where there's a referendum, there are often obligations on the subject, publishing information about the subject matter of the referendum, which can take place during the pre-election notice period and is quite lawful. Nor to correct factual inaccuracies which have appeared in publicity produced by third parties, as long as it's even-handed, objective, and doesn't support or oppose options which are subject to the vote. I will come on to correcting factual inaccuracies later, because it's one of the danger areas that people can get trapped into. Next slide, please. And we immediately hit factual inaccuracies. So if it's established that a factual inaccuracy is there, then it can be corrected. Only those inaccuracies as may be identified can be corrected, and the council can't go on to explain or otherwise summarise or interpret, save as is necessary to correct a factual inaccuracy. There are numerous occasions where people have sought to rebut a leaflet from a political party saying that the existing administration has done this and a letter must be sent to all residents has been the cry. So first of all, there's a little sort of checklist to tick off. The council needs to identify what inaccuracies existed. They should be cited in the correction letter as well as the correction. There is a big difference between a factual inaccuracy and a difference in interpretation. You have to pick that apart quite carefully, because the former is a lawful basis for issuing a correction, the latter is not. Even if a factual inaccuracy can be identified, there's still the requirement to demonstrate a need to issue a correction in all the circumstances. Timing is critical. The more distant in time the inaccuracies, the less likely the need. Equally, if earlier statements have been superseded by subsequent media reports, this lessens the need. So what is the need to do this? Lawful need. The council must be clear that there is a legal need for correcting the inaccuracy as compared to returning the matter to the political arena to be debated between the parties as part and parcel of the normal round of pre-election debate and manoeuvring. And bear in mind that matters raised are likely to relate to electoral issues that participants in the election could reasonably expect to debate and discuss in a political arena. This is a democracy, and sometimes people are going to raise those sorts of issues to discuss, and as such, the council has no role in participating in the debate. and must take care to ensure that it remains strictly apolitical. So in dealing with factual inaccuracies, one then comes on to say, well, who should make the decision? Where the council decides to issue such a correction, the decision should be taken by the chief executive or senior officer, but not the returning officer, who should consult with professional advisors. Consultation with members may not be necessary or appropriate, depending upon the circumstances. But the chief executive or other senior officer, whoever's tasked with it, should be the person who determines this. Again, this is something that I suggest might be included in the guidance, because once it is, it's much easier to deal with it, having delineated how the matter will be addressed in advance, rather than being seen to make the rules up on the spot when confronted with a difficult situation and needing perhaps to say no to a bunch of senior members who expect but are not going to be satisfied. I've also mentioned there the application of the regime to other elections not affecting your authority, but applicable to your area. The code apply whether or not, as I say, the council in question is having the election. Paragraph 33 of the code refers to elections and referendums, and it says publicity relating to individuals involved directly in the election should not be published by local authorities during this period. So just be aware. It can also apply, obviously, if you have a parliamentary election and no council elections. And it is even more acute if one of your parliamentary candidates happens to be a serving councillor. So there are, any election may trigger some or fewer response. What I would also say is that when one has, we don't have them anymore, obviously, but European parliamentary elections, I think most of us who were both returning officers or regional returning officers, as I was, and or monitoring officers, would take perhaps a slightly different view because of the European context rather than the local context. The need in those cases to have any significant restrictions, or the level of restrictions one might have on a council poll, was perhaps a little bit less. So there's always a judgment call in terms of how you balance it. But what is absolutely clear is that if you have an election in your area but it doesn't affect your council, the code and all the regime and the rules relating to heightened sensitivity may still apply and need to be taken into account. Next slide, please. Now, quite a lot of the issues that arise still don't fall within the code, but they do fall within what I've called practical and operational issues. And they're no less significant for that, but they don't necessarily have a significance or weight that has underpinning legalities where somebody can look to a lawyer and say, and we mustn't, or we must do this, right? To which the answer is no, it's a judgment call, and somebody needs to make that judgment and say, this is not something I think we should be doing, and this is why. I think the first point to make is that normal rules for decision making apply in the pre-election notice period. There is a but coming, but normal rules apply, and that's the starting point. Persimmon Homes, which was 2008, a decision to grant planning permission on a controversial issue failed to be determined during the pre-election notice period, and was featured in political literature kicking around at the time. The High Court decided there was evidence of predetermination and quashed the decision, but the Court of Appeal overruled it, saying that the elected councillors have to bring their experience and knowledge to the decision-making process and won't come to the committee room with a closed mind, or indeed a blank mind. The Court of Appeal held that there was no evidence of members having predetermined the issues. There was a predisposition towards an outcome. You will know the difference between predisposition and predetermination. Predisposition, I'm minded to do this. Predetermination, this happens or doesn't happen over my dead body, etc. There was no evidence of predetermination, as I've said, and the local authority could therefore decision-making proceed, and the decision that was made was deemed to be safe. And crucially, it now confirms that local authorities are not precluded from the conduct of normal business during election periods. There are buts. The first is the council must never disregard the potential for an unfair electoral advantage or disadvantage by their actions. But any presumption of a freeze on decision-making is fraud. Business as usual is the starting point, but there needs to be some judgments. An ill-timed decision, for example, to make a determination on school closures during the pre-election notice period might be within the Persimmon Homes definition of what's acceptable and might be quite lawful, but would be profoundly unwise if it was highly controversial, because it would dominate potentially the election and could distort not only the decision making but also the electoral result. and that will be best to be deferred. Not because of something in the legislation, but because of a practical or operational reason. And it's those sorts of situations where there is that judgment call to be made. There's further help to support, however, decision making, if I could put it like that, and the legality of that, because the Localism Act 2011, Section 25, it statutorily codified the issue around predetermination and predisposition in essence. So it's worthwhile bearing in mind that if you get a query as to why decision making is continuing, and why people are going out in their election literature saying things, surely this means they can't sit, and so on and so forth, it's always fact specific, particularly around declarations and the rest of it. But do bear in mind that predetermination, predisposition was discussed at length in Persimmon Homes and also is now covered off within the Localism Act 2011. Next slide, please. Other practical or operational issues is and it's an obvious one, the availability of members. I don't know what your members are like in the pre-election notice period. Southamptons tend to be out on the sticks delivering leaflets at God knows what hour of the morning. And yes, I get lots of complaints and leaflets being shoved through people's letterboxes at 4 a.m. and being visible and doing stuff. And they're not always as available, particularly in the last 7 to 10 days prior to poll, as they might normally be. And they really don't want to have lots of extra meetings if they can avoid it. The mayor carries on doing all of his or her engagements, Lord Mayor, I should say now, in Southampton, of course. But generally speaking, lots of the members are less available. So practically speaking, there may be issues. I've mentioned the issue of distortion of decision-making during the pre-election period. It's a real judgment call, but it might be a completely valid reason for deciding to defer something. Effect on consultations. I mean, I think on consultations, I would badge it as two very distinct things. If you've got a highly technical consultation about something really detailed, not politically contentious, I don't know, something around environmental health standards or whatever else it is. I don't say taxis because they're usually incredibly contentious, but something that is professional in terms of its nature, perhaps, and as I say, completely not contentious, then fine. If you've got school closures, highly contentious usually, let's assume this one is, you don't want to be carrying out that consultation process during the pre-election notice period, because it's going to impact potentially upon the election, it's going to impact upon the consultation, and you might end up with a distorted and incorrect decision as a result of that. So all sorts of reasons why some consultations may be best deferred during the pre-election notice period, which means the decision may be deferred from outside the pre-election notice period till after the poll. FOI requests may come in during this time to the council. They need to be handled just like any other FOI request. The fact they come in from a candidate or anything like that, the council has to deal with them. Bear in mind, FOI requests made of the returning officer will decide what they do, but the returning officer is not a public body for the purposes of the Act. Guidance. Now, it's a matter for each individual council, the monitoring officer, the CEO, but I do highly recommend you consider issuing some guidance around the pre-election notice period, and not just what it means, but how it is approached within your particular authority. Southampton may have had its own particular madnesses during the time that I was there, probably nothing to do with me, but nevertheless, we had a lot of issues on this, and we spent quite a bit of time not just figuring out how we were going to draw the line in the sand about what was acceptable and what was not, but also when we got into the practical and operational issues, I didn't feel that was for me to try to find a legal justification for something for which there was none. If the director responsible for education felt it was necessary to defer some work that was being done on school reorganisation until after the election, he, she or it should have the ability, authority, but also be the one who is responsible for standing up and saying, this is my decision. Or when it came to the use of buildings, again, the relevant director with the lead for that particular functionality should be the one who decided whether they were going to allow candidates to have their photographs taken or not the monitoring officer, certainly not the returning officer. So some guidance, whatever you include in it, and it's a matter of a local choice, I think is helpful, but reflecting always upon what went well last time and therefore what you need to include in it. So if you look at a lot of people's guidance and you're starting from scratch, and we produce a template, by the way, which is just a starter for 10. And if anybody wants one, email me after this, happy to send it to you. it should be localized. It should always reflect your local circumstances, and with something that didn't go right last time, pick it up and deal with it. As I say, I err on the side of including probably a lot more than other people include when it comes to Southampton, but that's simply because we include a lot of stuff that deals with who is responsible for making decisions on practical and operational issues, and also corrections, by the way, where it's the chief executive. So issuing guidance can address roles and responsibilities at the same time. If you're the MO or head of legal, beware the hospital pass. Really beware the hospital pass. This is the point at which, if you're not careful, you can find everybody expecting you to find a good reason to stop something that perhaps shouldn't be stopped. But they'll look to you to do it. And I'm afraid that does happen a lot. And a lot of the time, the advice we're asked to give is, I don't really have the legal power to stop this, but I can recommend it stopped, but they can ignore me, to which the answer often is yes. So practical and operational issues raise issues, but I think having guidance, a line in the sand, issued before the notice of election goes out, sent to senior officers, sent to all members, they probably won't read it, but at least you can say, oh, well, I issued this on the 15th of March or whenever it was. This is what it says, so this is what we're going to do. Next slide, conclusions. So be aware of what it means and its impact. Understand that it's a matter for the council and not the returning officer. If you are the returning officer, you can wash your hands of it, although you may need to dabble behind the scenes if you're Jill-hatted with the MO. If you're not the RO, keep it away from the RO. If you are the RO, don't involve yourself unless you absolutely have to, and try to find a way of separating yourself. Ensure the role, if you are dual-hatted, and the basis of any device and which hat you're wearing is made clear, however you do it. But if you can find a deputy to do it, so be it. And that really is important. I suppose the other couple of things I would just say as well before I pause and invite comment, question, etc., is do bear in mind the fact that the code will always apply, including during the period of heightened sensitivity from the notice of election up to the close of poll. So it's not just those extra paragraphs that apply, it is the generality of the code. The target is local authority expenditure, public expenditure on publicity designed to influence the voter. So if there's no expenditure by the council, there's no activity by the council, hence no expenditure, or there's no flashing the cash by the council, or there's no payment for a camera crew, or there's no organisation by the comms team of the event, the councillor, the candidate goes up and does their own thing, nil expenditure, nil input from the council, there is unlikely to be an issue. Always fact specific, but again, at the risk of being very obvious, it's always worthwhile, and we always used to have a system at Southampton, which I think still exists actually, which Richard uses, whereby democratic services keep a very careful eye on the forward plan and all the other decisions likely to come forward during the pre-election notice period, and flag them up if they look like they might be contentious or difficult, because things can creep under the wire and suddenly you find yourself looking at a decision that's been programmed which probably shouldn't have been programmed. And the time to do it is before it hits the forward plan, not after, as you will fully understand. So aside from that, I hope that's helpful. I've mentioned the template that we produce, which I've sent out to a number of colleagues already, having mentioned this at an LLG elections event that I was talking at. But if any of you would like the template, please do email me. M Heath, all one word, just the initial M and then HEATH at vwv.co.uk. I think my email is going to be on the very last slide, but if we go to the next slide, please, Romany, and pause there. I'll take any questions.
Mark, I think everyone's gone a bit quiet, so I'm very happy to come in and pick your brain, hopefully on behalf of some of the delegates on the call today. Mark, the judgment call as a monitoring officer at a few councils, the judgment call I think is often the more difficult when you're not pointing to something that's a statutory obligation. Can I check with you, please? Do you have a pro forma or the best way to record those sorts of decisions? Because obviously a judgment call is something that can be challenged at a later date.
Yeah, I think that's absolutely fair, and I think they need to be recorded. I used to work on the basis, I don't have to do this anymore, thank goodness, but I used to work on the basis that I would always record it in the form of an email and follow up whatever advice I gave, which might be verbal because of urgency. And I did that pretty formally, simply because I wanted a record of, you asked, I advised, this is my recommendation, etc. I had to do less of the practical operational ones because I had fended them off to other people through this process. That had two impacts, interestingly. The first of which, they suddenly became much more adept at not putting up school closures. And I know I keep on saying that, but once you've been burnt by one of those, it's something you don't forget. Much more adept at not putting up school closures in the notice of election, etc., because they knew if they did, they'd have to front this up. So actually they became more aware of and mousy about it. So yes, absolutely, it needs to be recorded. And if it's a decision being taken by a different person other than the MO, absolutely they need to record it as well. Yeah. But what it did in our place was it stopped them doing things and then somebody else having to bail them out of it. I did just see a question go on through on chat, by the way. The question was, does this apply to by-elections? The answer is yes.
Mark, I've got another one. If while we wait for any more questions to come up, Mark, when we talk about the resources and other assistance that can be offered in the guideline to members, would you go as far as reminding them about using their council email, using their council laptops, using our printers, all those, you know, because they're the sort of resources where, you know, you see your cabinet members in late at night and they're on their laptop and you know it's not their work emails. Is that the sort of thing that you would put in those reminders as well to members?
Oh God, yes. And I can't remember how many times I would pass the members' room in Southampton and hear the photocopier achieving white heat and walk in and find 1,000 Party X leaflets. So the short answer is absolutely. I'd reiterate that and point out that for serving councillors, that can be a breach of the code of conduct as well, because it's misuse of public resources through the code. It certainly was in Southampton. But yes, I would absolutely cover off council resources. And I have to say, we used to get quite a few queries with people saying, how come I'm getting an email about the election from Councillor X on their council email system? I was less bothered about that than I was, if I'm honest with you, as to the people doing 1,000 tons of photocopying because they were copying their leaflets on, because that had a real cost and also was more like publicity. But we did absolutely cover all that off. And just for the avoidance of doubt, by the way, again, picking up the by-election point chat, which I've just seen go past, yes, it does apply to by-elections. And yes, we would issue guidance for by-elections. That's council by-elections as well as general election by-elections. And when we were dual-hatted, as we were back in the day, we would do it if there were county by-elections as well. Although we would probably have a slightly softer approach. Any more questions, I think I will say.
Hi, Mark. Hang on, I'll just get my camera on.
I've just seen a chat where somebody says that they've seen lots of stuff in members' links. I think that if you have members' blogs, you need to go look and see what there is in any way, shape or form already up there, not just shut them down, but leave what's live there. There may need to be some editorial control. And what I've also seen happen in some cases is then an outcry because members didn't know that their blogs might be edited. So that can sometimes drive a need to reissue guidance to members about what the council can and cannot do on hosted blogs and so on and so forth. But I think it's either shut the whole lot down and clear them off so that they're not visible at all, or you will have to go through the lot and decide what you do and don't censor. And the best of luck with that.
There's one more question here, Mark. What are the consequences of failing to comply with the code and the process by which to challenge?
It ultimately comes down to an issue of legality, and the challenge can come in two ways. I've seen the challenge come in two ways where it gets hot and heavy. One is through the courts claiming that the council failed to have due regard to Section 4. That didn't go anywhere because it didn't have any wheels, but somebody did attempt to take it to the courts. Basically a JR. More frequently, I've tended to see it raised with the external auditors. on the basis that the council has failed to basically spend its money properly or account for its publicity as indicated at the start in a separate account, because somebody has done an inspection of the accounts and has raised an objection because the money has been unlawfully expended. I have to say as well, it's been used on several occasions by people wanting to try to challenge a result or put the returning officer on the spot. That's easily fendable, offable. It's got nothing to do with the RO, provided they haven't done a dual hatted and forgotten which hat they're wearing if they're the same thing. But it's potentially JRable, but it's not happened yet, to the best of my knowledge, that it's been directly pleaded, but people have had a go. It's more likely to be through the external auditors, through the accounts process.
Fab.
Oh, I should say, by the way, reputational damage, there is always the thing that comes out of this as well, but I will park that and just say that does sit there.
Lisa, have you got any more questions?
I would say there's just one aspect of Mark, you're absolutely correct in saying, about issuing guidelines, issuing them early. One thing that we tried to do at a previous authority that I've worked is to actually try and incorporate it into your service planning, because it's amazing that someone will map out the next 12 months and there'll be a consultation issue in March and they haven't even considered I've made a call on cutting consultations short where they have been controversial, and that doesn't go down very well, and you're not very popular when you make those decisions, but they're the right decisions to make. And if they'd have just planned that a bit better. And I also think something going out to a council's project managers who are, they've got their 5-year Gantt charts. Every March there should be that little window which says, start of the pre-election period, because, especially elections and thirds, it's coming round every year. But people do tend to forget about that, and it can throw some really big regeneration plans off, and that makes you pretty unpopular with both senior officers and politicians alike. So that's another little tip where I found that to be really helpful.
I think that's good. I think that's a very good point, because the more proactive you can be, the less crises you have, and when the least amount of crisis management you can do in the pre-election notice period, the better. Very good point. Thanks, Lisa.